as a health professional with a certain standard of medical ethics that I agree to 17 plus years to say, when this patient sits in front of me, it's my job to make sure that this patient is already vulnerable. This patient trusts me with information that he or she would probably not share with everybody out there. It is my job to say, I will do to the best of my ability, protect this information, because we are now working on a sensitive issue or a vulnerable issue, and we need to get you back to health.
So somehow the medical system has really been left to be taken over by people who have an agenda for running without having the patients in their care.
And I showed up in the town hall meeting and I asked our CEO certain questions, not even driving any agenda, just asking questions on, is there really informed consent? Do people know that these are still in experimental phase? The medical ethics questions, and the CEO was not able to answer my questions. And I really do think he was, at that stage, it came across that he was the weak link in the story because he wasn't prepared for that meeting.
Even to the point of self-injury and harm and death, a person can choose whether or not they want a medical treatment or not.
At the end of the day, my role as a physician never changed. I'm still a physician. Even though my license has been temporarily suspended going on 2 years now, I'm still a health advocate. I'm still a health scholar.
Good day, ladies.
Good afternoon.
Thank you very much for joining me on my podcast today. We're going to have a conversation between the three of us. I'll do a quick introduction and then I'll let my guests tell you what they would like to talk about today. So first on the right, we have Dr. Kilian. Dr. Kilian has been educated in South Africa to become a doctor, but she's come to Canada with her family and has been working here for a number of years and run up against Canada's healthcare system. So that's partly why, well, mostly why we're here today. And then Amina. Amina's a lawyer, and you're a lawyer, correct me if I'm wrong, for the patients that are standing with Dr. Kilian?
Yes, I'm a lawyer in Ontario, and I represent the patients of Dr. Kilian who wish to assert a privacy interest in their health information and their medical records.
Mm-hmm. And so there are two court appearances coming up on October the 11th, that's correct?
Correct.
And one is for the patients and one is for Dr. Kilian?
That's correct. Do you want me to give you a little bit of
Sure, go ahead.
Oh,
yep.
Okay. So this all started back in fall of 2021. In Canada, we had vaccines that were mandated, that were required by pretty much across the board all employers and institutions, including educational institutions. And so for individuals who wanted to continue to participate in life and continue to earn a livelihood and continue their education, but who had chosen not to get the COVID-19 vaccine because that was perhaps not the right decision for them and their health, were really hard pressed to continue to do so, to have their choices, health choices, validated and not punished. So they, sought out medical advice and assessment, and after a thorough medical assessment with Dr. Kilian, they made the decision to exempt themselves and not get the vaccines, which is their constitutional right in Canada. So what happened next was that because other individuals in the lives of some of these people, and because of Dr. Kilian's public statements, some random individuals in society that were neither patients nor doctors made complaints to the college. And on the basis of those complaints, the college initiated something that is quite extraordinary, which is a registrar's investigation. So because they don't have a complaint from a patient, the registrar uses their power to investigate Dr. Kilian. And in the course of that investigation, they demanded the release of all her patient files without their consent. without their knowledge. And when Dr. Kilian attempted to obtain that consent, my client said, no, there's no need for anyone to access our personal information and our health information, because we have experienced no harm or injury from making a free and informed decision about our health. What happened then was, because of Dr. Kilian's refusal to provide the medical records without the consent of her patients, and because she also was questioning the legality of the investigation in the first place, that is it really meeting the requirements of the statute to actually promote the public interest and to protect her patients, or is it politically motivated, where the registrar is perhaps abusing the power that they have to initiate investigations? So because she was legally challenging the authority of the investigation, the college took her to court and demanded an injunction for the release of the patient files. That's when my clients decided to also bring their own application in that same proceedings to say to the court, if you are going to be determining whether or not these records ought to be released, you have to determine, does the college have legal entitlement to them, and are they relevant for their investigation? And you have to also look at how it's going to impact our charter rights, which is our right to privacy and our right against unreasonable search and seizure, which are guaranteed by Section 7 and 8 of the charter. You have to also weigh that in when you decide what to release and how to release, or whether to release at all. And so they brought in a motion to intervene. So you would think,
when was that? When was that?
This was in early 2022. Mm-hmm. So when the you would think, if the college is acting in the public interest, which really is according to their legislation, the Regulated Health Professions Act, the members, patients, that's how public is defined. The public is defined by the patients that the health professional is serving. That's who they have to protect. So if they really, that really is the focus, they would have welcomed this opportunity, and they would have said, we want to hear what you have to say, patients, because we believe in patient autonomy, and we believe in patient, participation in this process, because after all, it's you that we're protecting. Mm-hmm. Instead of doing that, instead of consenting to their participation, instead of allowing them to play a role in that court proceeding so that, the judge would have all the issues in front of them and could make a fulsome and fair decision, what they did is they vehemently opposed the participation of the patients, and they railroaded them into being basically kicked out of that court by saying that they should go to another court, to a divisional court, because if they really are interested in challenging whether or not the registrar has the authority to do their job, they should be in another court. So the patients went to the other court, which is divisional court. Again, in that forum, the college brought an application to quash their participation. Again, I would repeat, if the college is acting in the best interest of the public, which is the patients of a doctor that they are regulating, then they would want to hear from them, that they would invite those comments. Instead, they brought a motion very aggressively litigating and also demanded costs. So the patients were quashed by the divisional court because...
What were the costs that they had to pay?
$8,000.
Each of them?
$80,000 amongst there's about approximately 30 patients that...
And so $8,000 in all?
Yes.
Okay, $8,000.
Yes. Mm-hmm. So as a result, the patients were unable to participate in that divisional court hearing, and it was a judicial review of whether or not the registrar was acting within its power. The divisional court decided, it's premature for Dr. Kilian to argue whether or not the registrar is acting within their power, because that's something she can do in the discipline tribunal at the college. And the problem with that, of course, is that in order to do that investigation and in order to refer the matter to discipline, the college has to have all the files. And so the privacy of the patients would be breached. And the Supreme Court of Canada is very clear in the decision of R versus O'Connor that if the right to privacy is meaningful in this country, then it has to be protected at the point of disclosure. Mm-hmm. So for the Divisional Court to rule that way is backwards, and that's why the patients have filed an application to have that Divisional Court decision appealed in the Court of Appeal. So that's where we are
on
now.
October the 11th.
So that's where we are now, where the appeal of the patients from the Divisional Court and the appeal of the patients from being denied intervenor status on the injunction are all coalescing on October 11th at the Ontario Court of Appeal.
How many patients are there
that
are standing up?
Yeah, there are approximately 30 patients.
30. That's quite a few. And that's encouraging to hear that many people want to stand up and say what they need to say in this day and age, because it's hard to get people to stand up. Now, Dr. Kilian, maybe you could, because the people here, now they know what the patient's story is, but they have no idea what your story is yet. So could you please
Thank you, Tammy. And I think
give us the lowdown?
I'm grateful for this opportunity. I think trying to get the story of 2+ years into a little show, I'm going to try my best to condense it as fast and quick as possible. I wish I was here being able to speak about positive things and how we can get people healthy and what we can do to change the healthcare system, because at the end of the day, my role as a physician never changed. I'm still a physician. Even though my license has been temporarily suspended going on 2 years now, I'm still a health advocate. I'm still a health scholar. So I would love to come back and let's talk about positive things. But obviously today I'm here to speak about the court case coming up on the 11th of October. Basically, I'll start the story from the beginning and get it through. But basically, we are at this stage with my court case that if we lose this appeal, we've gone through many divisional courts and superior courts, all of these steps, and we've lost every single step of the way. The courts have been definitely biased so far. But if we lose this appeal, the only way we have to take this further is to go to the Supreme Court, which ironically, my husband is a lawyer. And when this investigation started, he said, he really does believe this is the one case that has the opportunity to challenge the college on things that they've been getting away with for many, many years. So as Amina said, yes, the investigation was started by the registrar in 2021, October of 2021, when one of these exemptions, I assessed the patient, had full consultations with them. It's part of telemedicine, so it was virtual assessments. One of these exemptions was handed into an employer. That employer decided that he or she was not happy with this exemption provided, and that was sent into the college. No patient.
Now, why would they do that? Why would that employer do that, do you think?
I think the easiest answer is that employer was basically following the same narrative that everybody was following. And the narrative at that stage was that there really was no reason for anybody in Canada at that moment to deny taking one of these experimental biologics. So that person was literally just basically acting in the message that he or she was being fed every single day by every physician on the TV, on CNN. So the idea was that if the person wasn't accepting the narrative of taking the vaccination at that point, what were you offering that was different? At that stage, we had a whole consultation where people that actually came to see me, at that stage, they had family physicians. They had medical histories, things like antiphospholipid syndrome, cancers, previous cardiac concerns, blood clots, all of these things that we know would put you at a higher risk of getting side effects or adverse events after an experimental, like the COVID vaccines that came out. So by the time they got to me, I said, well, we have to make that decision. We either delay you getting the vaccine, or we make the decision to say, with your demographic and your profile, your history, the risk of taking the vaccine outweighs the benefit of you either get at that stage, they said they can prevent you from getting COVID and spreading COVID. With the data coming out, we know that wasn't accurate anyway. So it was a conversation, a little conversation that usually happens between patients and physicians, and those decisions were made. The exemption that was handed in did not say what the medical condition was because of privacy and confidentiality. Nobody is supposed to know what your medical state is. That's been upheld forever in medical ethics. It's the first time in
So all they were doing was saying, I'm not going to get the vaccination.
Exactly.
That was what they were doing. Okay.
So that was the first thing that started the investigation. The other was, as Amina said, after resigning from my work as a merge physician in the hospital, and we'll provide the link, there was a publicly recorded town hall meeting when the vaccine mandates came into the hospital with Directive 6. We got an email saying, from next week on, you'll have to have proof of being vaccinated, otherwise there's repercussions from that. And I showed up in the town hall meeting and I asked our CEO certain questions, not even driving any agenda, just asking questions on, is somebody going to be following up with any adverse events? Is there really informed consent? Do people know that these are still in experimental phase? The medical ethics questions, and the CEO was not able to answer my questions. And I really do think he was at that stage, it came across that he was the weak link in the story because he wasn't prepared for that meeting. At the end of that town hall meeting, I ended up resigning from my work as an emerge physician. I worked at that hospital for 4 years. I was recruited from South Africa specifically to that hospital because of my experience and my qualifications. So that's when I stepped into assessing people for COVID care, because I knew at that stage people had nowhere to go. They couldn't see their family physicians. Most family physicians' offices were closed. They couldn't come to the hospital because they were too afraid to come to the hospital. And that's how I kind of got dragged into this. Long story short, the investigation was launched by the college. They sent us a letter to say, they didn't say why I was investigated. All they said is, you have 7 days from now to provide us with a list of every single patient that you saw for an exemption, for mask exemption, vaccine exemption, hydroxychloroquine, ivermectin prescriptions, or even PCR testing exemptions. So they kind of just threw everything that did not fit in with their narrative or their guidelines, as they called it, not policies, guidelines. They asked me to provide them with a list. And luckily, once again, with the guidance of my husband, that's a really good medical ethicist, we said, you know what, we would love to comply. We love cooperating. I've been working with the college. I've never had one single complaint in 17 years of my medical medical practice. We would love to comply, but there are certain rules that we have to follow. On the college's website, when you as a patient or a family member of the patient goes into their system to lodge a complaint, on the complaint form, it actually says this is going to be filed, but this complaint form needs to be sent to the physician so that the patient can provide the permission for this chart to be shared. So they came up with these standards and these rules. It's not my fault, really, that they haven't been following it in the last few years. So at the end of the day, they knew that I was not going to be providing it without the patient's consent, and that's when they took me to court. The Section 87 that they did it under is actually a pretty serious type of investigation that if I wasn't practicing out of my home, they would probably have tried to raid my office, because that's exactly what they do with other physicians. They really don't have way to keep these people out. They come into your office, take your computers, take all your charts, and then they go out. But I was practicing out of my home, so that would have been a violation of my privacy into a private property. So that's why they couldn't do that. So that's why I've been stuck in court. In the process, they ended up suspending my license, so I've been without an income on our way to make an income as a physician for the last 2 years. And that's definitely put some interesting challenges on our plate.
What do you think, how do you think the medical boards, the people who are running the hospitals, are getting away with this? You know, when we're I'm just thinking about our political system. And what is good information for the next election? Hospitals aren't going to be high on that. They're not going to be paying attention to what's going on in hospitals, because that's not a big pull for getting points and getting voters going in your direction. So somehow the medical system has really been left to be taken over by people who have an agenda for running without having the patients in their care, like the students in our schools being the most important thing in the school, like they are the ones that are the necessary, and they're the vulnerable, and the whole system is set up to be in their best interest. And this is, it's like it's been completely abandoned. This whole idea of patient care, of student care has been completely abandoned. And it seems like I don't know what you think of that, but our political system just is not, it's not nourishing our all of our government run lower down local, feet on the ground institutions. Those things are being taken away and used in nefarious manners. And you guys are seeing this firsthand in the medical system.
Absolutely.
And so we're talking, last week, the people, the parents were frustrated, and they were coming out in thousands to say, no, our schools aren't being run properly. But we have a medical system that is also in a terrible way. And I don't think people really know. I think they know more about the school system now because people are starting to rise up. But this is why we're talking about this today, is our medical system also is being taken and run by people without very much care.
And without regard to the mandate and objective that they are appointed to do, right? So the irony of all this is that the college is able to sway the judiciary by saying that they're protecting the public interest, that they're acting on behalf of the public. And who is the public? There is no mandate for the CPSO to protect the random public. I mean, that's the job of our police. That's the job of other institutions. So this is clearly a case of regulatory overreach. It's really a case where there is no judicial or legislative oversight of what's happening in the executive. And that whole, checks and balances on power that we have between the judiciary, the executive, and the legislative is broken down. It's broken down because one individual, the registrar of a college, can get up in court and say, I am acting on behalf of the public. And they have a duty to do so. But under the Regulated Health Professions Act, the Minister of Health has a duty to ensure that the registrar is actually acting in the public interest or not. And they can't just be bamboozled by her invoking that. It has to be something concrete. And here we have no evidence of injury or harm. We don't have any evidence of a patient falling sick. We don't have any evidence of another doctor saying, I saw this patient and they had a vaccine exemption and they shouldn't have, and Dr. Rochagne must have done something wrong. There is no misconduct that's been defined here. And yet it's this, they've conjured this up that somehow she engaged in misconduct by respecting the constitutional right of a Canadian to exempt themselves from a medical treatment, when that is actually what our Supreme Court has said in the Carter decision and the Rodriguez, and in so many decisions has said that even to the point of self-injury and harm and death, a person can choose whether or not they want a medical treatment or not. And so for the registrar then to say to the profession on a whole scale through a message, it's not through regulations. It's not enacted through statute. It didn't go through the checks and balances. The legislature never put their mind to it. But all the registrar did is send an email message to all doctors to say, you cannot give an exemption to any patient unless they've already had a vaccine and been injured, or they have an autoimmune, they have an anaphylactic reaction to the vaccine. So, in other words, there's no
free will.
Exactly, there's no such thing. So, where does the registrar have the authority to override our Constitution, override our entire Supreme Court of Canada case law respecting the choice of individuals to refuse medical treatment through an email to doctors? So what the patients are saying is this is an unreasonable interference with the doctor-patient relationship. You cannot be dictating to the medical provision what to do and what not to do with the patient. And so the only way the patient's voice can be heard in all of this is if we get to participate in those proceedings. For the registrar to take a frivolous or bad faith complaint to the college and run with it and invoke the powers that she has under Section 75 and the extraordinary power of suspending a doctor from practicing medicine, which should only be done under Section 25 sub 4, only be done if there is evidence of patient harm or injury of the member's patients. So they don't have, there's no patient at all that has any injury or harm, let alone any evidence of it. And so this is a classic fishing expedition where the college is trying to find something on Dr. Kilian in order to make out some type of misconduct, which they have not even defined or have an idea about. And they're using the patients as a bait to do that. And so the patients are saying, not in our name. But the judiciary refuses to hear them because they say, you have no place. This is just a private conflict between the regulator and the doctor, and you have no business interfering in it. But it's the patient's information, right? It's their personal information. So if that is going to be released, then they should have had standing. And that is what is wrong with the decisions from the Divisional Court and the Superior Court. And this is why this case is so important, because it impacts not just Dr. Kilian's patients, but it impacts every health professional and every regulated professional in Ontario. So
I was a massage therapist and for years and years, and I was asked to sit on the college board or I was asked to sit on the college. And so I went there and I was supposed to sit in a meeting where they were evaluating new incoming massage therapists who had finished their training and written their board exams. But there were two massage therapists and two members of public and myself, a massage therapist, and they were deciding to look at the history of the massage therapists. So they would, one person in particular who had come from the Ukraine and then come here and done his training and everything, but they looked back in the Ukraine and found that he had a drunk driving, and so they decided he shouldn't become a massage therapist. And I said, well, he's come to Canada. He's shown that he did everything that you asked him to do. He's written the exams. He passed them. As far as I'm concerned, he has the right to become a massage therapist. And they fired me from the board because they didn't want anybody on the side of the massage therapists. They wanted to take that power that they are finding they have and can twist and manipulate these professionals who have gone through all the hoops that they're supposed to, all the professional hoops they're supposed to, written the exams, paid for all of that, yet they're sitting in a room saying, as far as we're concerned, you aren't ethically able to be a member of this college and in good standing. And I was like, you guys have gone off your rockers. And that was 8 years ago, probably.
Yeah. Tammy, I think
so it's in all the colleges.
Absolutely. Every single regulated profession is exactly the same. And that's, I think, the part that people really need to understand. What came out in the courts, and it's quoted in this document, and this is what the college came out and said, and the judges actually rubber stamped it because they agreed. They said, and Amina, you can correct me if it's not exactly worded correctly, but it said, Canadian citizens have no expectation to privacy as it relates to their medical health. That, at the end of the day, is the message that comes out of it. Is there reason for Canadians to be worried about the fact that they don't have any privacy to their medical health? Anybody can decide for themselves how far of a issue that is for them. But as a health professional with a certain standard of medical ethics that I agree to 17 plus years to say, when this patient sits in front of me, it's my job to make sure that this patient is already vulnerable. This patient trusts me with information that he or she would probably not share with everybody out there. It is my job to say, I will do to the best of my ability, protect this information, because we are now working on a sensitive issue or a vulnerable issue, and we need to get you back to health. Or you need to make decisions where you're not influenced by outside forces. It's your decision, but we are here working together on that point. So it's actually such a big issue. The problem with this is, I think the one part that people need to realize is, if I wanted to stand up in this court case or this whole investigation for myself to really get to the point that I want to go back to work, I want to prove that I'm a physician with standards and I am competent, it would have been very easy to open up my medical charts, because I'm very proud about my work. I actually take pride in my work. I enjoyed my work. I've got a medical chart for every single patient I assessed. The issue is that the allegations was that I was handing out exemptions like candy without any proof or reasonable and probable grounds that that was true. So if that was true, I wouldn't be wanting to open the charts. I would love to provide the college with my medical charts. What people also need to know is that the patients did come and say that if you are getting our charts, we really don't want you to have our names and our particulars, that privileged part. The college was not willing to take even that deal, which means it's really not about just my medical charts. They want the details of every single patient. I have no idea why they want the list of patients that I assessed. Is it to go after these people for decisions they made? We have no proof to know about that. But at this stage, there's no reason for the CPSO to want a list of people's names and particulars, the date of birth, everything that makes it so that they can be identified to know, did they get the vaccine or not? So there's so many layers to this case that we can probably be here days and days on end kind of speaking to all of these. But at the end of the day, it all comes down in the protection of Canadian citizens' right when it comes to their healthcare. And you're absolutely right. There has been such a muddy situation where health is not actually a federal jurisdiction. It's a provincial jurisdiction. So the federal government has overstepped and overreached to such a degree in the last few years, but that has also been it also made it so much easier because all of these role players, the legislative, the executive, the Ministry of Health, it was so easy for all of them to blame the other group that we didn't put the public in this situation. You always had the choice. There was no real mandates, but people were put in a situation where they really did not have a choice. It was the illusion of choice. And that's why, in that regards, I knew my role as a medical professional still includes being a health advocate for a patient as well. If there is fear or the situation where they will be followed or victimized for their health decisions.
And just on that point, I want to say that when the college says, we are entitled to this information, that is something that Dr. Kilian is disputing, to say, I don't think you're entitled to it, because if you don't have a valid investigation, then your demand is also invalid. But leaving that aside, if there is a valid investigation, the college has said that you don't have to worry. We have a duty of confidentiality. So that's Section 36 of the Regulated Health Professions Act. But if you read Section 36, it has so many exemptions to that. And so one of the exemptions is if the college deems it fit under Section 36 sub 1I, they can disclose that information to anyone if they think that there's a risk. And this is the big problem that we're facing, because the elephant in the room is that COVID-19 vaccines are safe and effective. And therefore, if you don't take them, you are unsafe and you are putting other people at risk. And based on that, incorrect assumption, we have had so many policies and we've had so many violations of people's charters rights in Canada. And so when they say there's a duty of confidentiality and it's a perfect type of protection, whatever information you give us, trust us that it's going to be okay. It's not going to be okay because there are so many exceptions. And if it was okay, then what is the relevance of a patient's name to assessing whether or not Dr. Kilian did her job? What is the regulatory objective of an individual's name or gender or where they live or their telephone number? That is completely irrelevant. That personal data, which is distinct from health information, is extremely personal. And our Supreme Court has decided that if that is the kind of information that goes to the biological core of who you are, and therefore it deserves the highest protection in terms of privacy, for the court to then say you have no expectation of privacy in that information is really a distortion of the rule of law. And that's why these cases are problematic, because there is a result that the college is trying to achieve, that perhaps even the courts are trying to achieve. But by obtaining that result, the distortion of the rule of law that happens in the process is going to have consequences for Canadians for decades to come. Because what does it mean?
You want to go get a job and they look to see what ailments you've had in your past and whether you will be someone that they can depend upon or not. And that information has been private.
So basically
private.
We follow this precedent. What this means is that anyone who disagrees with a person's health choice can go and trigger an investigation against their doctor and then demand in that process access to all the patients that doctor serves. So you can imagine, a jilted boyfriend who doesn't want his ex-girlfriend to get an abortion. All of a sudden they're going to go complain. Or, anyone or someone who says, oh, you've got cancer, you should be doing chemotherapy. I don't think you should, be doing your naturopathic remedies. I'm going to go complain about your doctor because she respected your choice. So this could just result into any kind of interloping, meddling, interference with the medical choices of Canadians, because what will happen with this case is other doctors are going to say, well, I better be really careful and I better only follow the protocols that the college is telling me to follow. Otherwise, I'm going to get a complaint and I don't need that. So
were the complaints associated with social media, or were they all local? Was there any social media complaints?
No, mine was never. There is another physician, Calvinder Kaur, that was probably her, and Dr. Patrick Phillips, that was really more focused on social media. Mine was speaking in my own community after I was asked to come give my opinion as a medical expert and a medical professional to say what is the issues with rolling out vaccine mandates. That was the only reason I publicly showed up to these meetings. And we've got the proof. We've got the recording of every single speech I did. That was one part of it. The second part that I would say, one of the emails that was sent in by not a patient or a physician was the allegation that I was creating vaccine hesitancy with the way that I was showing up in public. And part of that is that I did a presentation on what I was seeing in the emerge department, people coming in with things that I had no way of knowing is it the vaccine that's causing it, or if there's something else going on? Because if you're not even willing to ask the question, we might be missing something else. A new pandemic showed up and we wouldn't even know because we were just so focused on one diagnosis. So that presentation talked about D-dimers and blood clots and things like that. And I do think that was part of it. They didn't specify it. What I need to kind of open up there as well. We've been in court for 2 years now, but the college, even though I have not been practicing, I haven't been able to practice as a professional, they launched a second investigation through the registrar. This investigation, and this is the ridiculous part of it, this investigation was based on the fact that I wasn't complying or cooperating with the second investigation. So they took me to court. We're still stuck in court for 2 years, but they decided we're just going to launch a second one so that we can get her into a tribunal for not complying with our first investigation. So that's where we're at this moment. But that's the only allegations out there or non-patient or non-colleague complaints that got all of this started.
Now, who pays for all the court costs and all the lawyer costs that the college ends up accruing? Is that tax money that
all
pays
of
for
us.
all of that? Or?
All of us.
Yeah, all of us.
Taxpayers' money,
right.
and
all of us.
Exactly. And Amina, I think Amina can attest to this. Certain things where it should have been probably 3,000 costs levied against the patients is now 9,000. The next one that they lost in court was 16,000. If they lose in court on Tuesday, it could be anything from 20 to 50,000 because the colleges shows up with a massive team of lawyers and they are just racking up fees because people need to realize that's exactly what these regulator or any government agency or institution does. They've got unlimited funds. They can rack it up because they know most of the time people that are in these court battles, they do not have the unlimited funds.
Can't afford it.
They can't afford to continue because this is exactly where we're at. I can speak to this probably better. The patients are at this point, they don't know if they can continue because they can't cover these costs. We've been very blessed. Amina, as well as my lawyer, Paul Solansky, has been doing this for 2 years, absolutely pro bono, with no fundraising. They've been paying out of their own pockets in some cases because there's filing costs that still goes into this without any help. Mm-hmm. And it's now at this stage that the college knows we're reaching the point where if I can't even afford to take this to the Supreme Court, there's no way we can continue, even though we know it has to reach that point. One part that I want to mention here, Tammy, as well, is what happens there was some other physicians that had similar cases, but not exactly the same as mine. There's nobody else at this stage that have been able to hold out as long to protect their patients' charts. And the story that I think people need to realize how these colleges work to keep people in line. Some of these physicians that ended up signing agreements to say, yes, we want to go back to work. We've got patients dependent on us. We've got our family dependent on our income. We need to go back as professionals. They make these people sign agreements that they will go for training, very similar to Professor Peterson, that they will go for retraining. That training, they pay for that training, and it's a few weeks courses that they have to go through. But at the end of this course, they have to show up in front of a panel and write an essay where they show honest remorse for their mistakes of the last few years. Basically, the fact that they had critical thinking and stepped up as health advocates, they have to show remorse for that, for them to be able to pass this education piece. You either get a pass or an unconditional or a conditional pass, and then you can go back to work, go back to your job. If you don't pass it and you don't show honest remorse and they don't believe you really believe in what you wrote in this essay, they can make you take this course again. I know of a physician, I won't name his name, he's taken it twice now. Then you still go back to your practice, but you've got a big red A against your wall to say you can't prescribe ivermectin, you can't prescribe hydroxychloroquine, you can never see a patient for any exemption, masking, vaccine, or testing. So you're going back, but you're going back with restrictions on your license. And I think this is the part that people need to realize. Physicians that are licensed in Canada, I can't speak to the psychologist, all of the other guys, I can speak to my profession only. Physicians that are practicing in Canada are not autonomous anymore. They cannot say what they actually believe. They cannot even say what the research is showing them what is the best choice for their patient group, because every patient, every physician has their own type of patient group and demographic. They cannot give an honest medical opinion anymore because of fear of going through what we've been going through for the last few years.
I mean, and that's not to say that the profession should not be regulated. The position of the patients is actually very reasonable. And that is, there are instances where doctors are doing wrong things. But you need evidence of it. So you have doctors that are prescribing, addictive drugs. Of course, they should have limitations placed on them. There are doctors that are abusing the power relationship that they have between patients and engaging in sexual abuse. Of course, you should have the powers to do that, but you should have reasonable and probable grounds. There needs to be some indication of patient harm and injury. Patient's well-being needs to be at the center of all your actions. And that's what is missing from this persecution against Dr. Kilian, is that there is no evidence at all of patient harm or injury, and quite the opposite. You have patients saying, you are harming and injuring us by breaching our charter rights to demand this information, which you could then go on and leak to other people. And yes, there is a real risk here. It's not unreasonable for the patients to say, we don't want other people to know our vaccination status. We don't want people in authority to know our vaccination status. Elsewhere in the world, they're arresting and quarantining people or their children for not being vaccinated. So they are really concerned about, why does the CPSO want to know? And secondly, the CPSO has no business to know who are the unvaccinated. And so for that reason, they've said, keep our names out of it. That's all we want. And the CPSO has refused. So their position is unreasonable. And in order to defend that unreasonable position, they have their own in-house lawyers, but they also have hired other firms, outside counsel, not just one, but multiple lawyers appear from multiple firms. And so it really is a David and Goliath type of situation where they have all the resources in the world and they can take all the unreasonable positions in law, and yet the patients are constantly being canceled from court because they are not being heard. They're being shut out from each court they go to, and they've gone several times. And they're being, and their doctors are being censored, and they're being censored because really, if the college were to fulfill its mandate under the Regulated Health Professions Act and the Health Professions Procedural Code, they would be listening to the patients. They wouldn't be constantly telling them to shut up and go away, and we're going to punish you if you don't. And that's exactly what's happening. So the Ministry of Health really needs to step in and give some oversight over the college abusing their power. The judiciary needs to step in and say, we should not be focusing on these technical arguments. We should be looking at, is there regulatory overreach? Because that's what judicial oversight is about in a democracy. When the judiciary fails and when the oversight of the actions of the executive fail, then we are no longer living in a democracy. We're living in an authoritarian regime where the regulator has absolute power and control and has the powers of the judiciary to, hold a discipline tribunal based on lack of evidence, and dictate to the profession what to do and what not to do through messages of the registrar and in emails, not through law. And so we have a disintegration of the rule of law. We have a dismantling of the checks and balances of power. And this is just the tip of the iceberg. And yet there's been a media blackout virtually on our case. We have had
Why hasn't
anyone heard about this case, right? So there has been we have had mainstream media attend court hearings. I've even had some reporters follow up with emails requesting clarification. and yet silence. Nothing is published. It's because if Canadians knew that this is what the regulator was doing, a lot more Canadians would be upset. Because we all believe that one of the most sacred relationships in our life, in our family's life, is that relationship between a patient and a doctor. That's where you have a lot of trust to be able to divulge, really personal, intimate details and know that they're going to be safe, because it's necessary for you to divulge that information in order to get the care you need. And so this represents not only an erosion of that, but it represents a real threat to public health and safety. Because now, if this is the precedent, patients are going to go to doctors and not divulge things because they're worried about stigma, or they're worried about, the college seizing their doctor's files without...
Or workers' compensation, not getting workers' compensation when they're harmed. And who knows where this will go.
Maybe somebody does have a communicable disease, but they don't want to disclose that to their doctor. So it's actually backfiring and having the opposite effect. And yet, like I said, there's a media blackout on this. And so thank you for getting the word out.
My pleasure.
And I really appreciate the opportunity to talk about this very important case. I hope your listeners will be able to learn more and get involved. My clients are part of another group of patients, because there is another doctor who has taken the same position. And they have formed an organization called Privacy is Your Right. And they are...
That'll be linked. I think that'll be linked with our website.
Yes, and I would encourage your listeners to go to that website, look at the resources that are there, reach out to the group and see how they can protect their privacy, because even though the cases have been dismissed in court, all is not lost. We still have a mechanism to address the overreach of the regulator through Parliament, through our legislature. And so I would encourage people to go there and see what else they can do.
Yeah, and the other thing that we could do is think about our affiliation with the legislature. Are we politically active? If we would like to be politically active, are we taking that responsibility and putting ourselves forward? Because we need good, honest people to save us from whatever's going on right now, which is not honesty and transparency.
Amina, and Tammy, I think I just want to add here, Amina touched on a very important point here. The CPSO is not my enemy. I've been a paying member of their organization for how long? I was a willing participant with their standard of care, their rules, the CanMEDS document that came out in 2017 that puts out the expectation and the role that I have as a professional. I've been upholding that. Just because the college have been swayed by fear, possibly with this unknown pandemic that we were all pushed in with 2020, who knows? Or there's a few bad apples in the bunch that have enabled the college to forget about medical ethics and standard of care, that have actually put the rest of their members, their paying physicians and licensed physicians, in direct harm's way by creating the atmosphere that they are no longer acting in a competent and a matter of upholding the standard of care. It is my job then, as a member and as a professional, with an internal integrity and drive for moral ethics, to say, I am standing in protection of the patients, yes, but I'm also holding you as my organization. I'm holding you responsible for the standard of care that you expected of me for 10 plus years that I was a member of these regulatory boards. That has never changed. So no, they're not my enemy. I would not want to disband it. We need CPSO, we need regulatory bodies, but we also need oversight of how these regulatory bodies are functioning, the procedures they are following, and what is their mission. Have they lost sight of their mission? And if they have, at this stage, we're not getting the courts to make them remember where their mission is. So we're going to have to look at other options, as you mentioned, political. And I don't know what the answer is at this stage, but there is something that is needed.
Mm-hmm. Now, do you have any final words to say? Because I think we're just about at the end of our time.
Amina, go ahead.
Well, I guess as a lawyer, I just want to say that I'm disheartened by the decisions. My clients are upset about the decisions of the court thus far, because access to courts is a form of access to justice. And if they don't have a voice on a very personal issue in the courts, then this represents a breakdown of, access to justice. And in the Canadian courts, we've had a real departure from what courts have normally done in the time of COVID mandates. Most courts, with the exception of the Federal Court of Appeal and the Manitoba Court of Appeal, very early on in the when the mandates were brought down in 2021, announced to the public that all their judges are vaccinated and they expect anyone who accesses the courts to be vaccinated. So by making that kind of pronouncement, what message are you sending to the public? That you've already made a determination of what is right or wrong. And the Court of Appeal, the Chief Justice, as he then was of the Court of Appeal, Justice Mark Noel, said the courts have no business doing that. They should not be pronouncing personal views or even institutional policies, because at some point these issues are going to come before the courts, and we need to be able to not only decide them impartially, but we need to give the perception that they're being decided impartially. And there's a famous saying that justice must not only be done, but it must be seen to be done. And this is something that's been completely undermined, and we're seeing the fruits of that now, where the rule of law is being really distorted to achieve the end result. And the fact that Supreme Court of Canada decisions were argued strenuously by myself and by Dr. Kilian's lawyer, but nowhere do they appear in the actual court decisions, is very distressing. Because at some point, if the court had to deal with all the Supreme Court of Canada jurisprudence, there is no way that they could come to that decision that patients don't have a expectation of privacy in their own personal information, in their own health information. That just belies, over 40 years of jurisprudence. So I am really concerned about this perception of justice, and I really hope that the Court of Appeal can reverse that and doesn't fall prey to it.
Thank you very much.
Yes, thank you.
Dr. Kilian?
Tammy, I think I want to say thank you for allowing us this platform to get the message out there. As Amina said, this has been definitely a blackout on this case. But I think there's three things that I would want to say to the Canadian citizens, maybe the US as well, your support base, is if every patient asks their physician the question, are you giving me medical advice because you believe this is the right advice, or are you giving me medical advice because you are afraid to lose your license? That's the first thing. The thing that people need to realize is if you do not have, as a Canadian citizen, the expectation of privacy, that's maybe the first shield that falls. What happens if the next line is you have no expectation of informed consent? You have no expectation of informed refusal. Whatever they decide to bring into our environment, if patients do not even have the expectation of privacy, I'm afraid we're getting to the point that they don't even have the expectation of bodily autonomy or to make decisions for themselves. And the last thing is I want people to ask themselves, why would a regulatory body try their utmost, pay law firms massive amounts of money to silence the voices of the ones that they are supposedly there to protect, who are they actually protecting? Because I do not think it's the public.
Thank you very much. Thank you both.
Thank you, Tammy.
Thank you.
And good luck in your court case coming up
Th-
on October 11th.
Thank you, Tammy.